Good evening to everybody. I am Professor Murali Karnam. I teach political theory as well as I run a program called Access to Justice. And it's basically related to providing legal aid to prisoners and also looking at the penal system from the point of view of justice. So that is a brief introduction. The rights of prisoners is a very complex question, and it cannot be discussed without discussing about the source of rights of the citizens themselves. Okay, so we need to talk about its source, that is the Constitution. I'll not I'll not deal with it elaborately because I'll only try to see how the rights of the prisoners are conceptually moved over a period of time. Okay. The first question that came up before Supreme Court in 1963 was, what is right to life in relation to prisoners? Is it equivalent to right to life of a citizen or not? Whether both of them have the same meaning when they talk about right to life. A right to life means, is it just an animal existence, or beyond that one should be able to think about it. Okay. In a case in which a prisoner was acquitted and still there was a continuous surveillance on the prisoner, he filed a case in Supreme Court in Karak Singh, saying that a continuous vigilance on me by the police even after my release from the prison is a violation of my right to life. The Supreme Court actually discussed a lot about what constitutes right to life in this case also. It also talks a little bit about right to privacy. Though it did not accept right to privacy as part of fundamental right, still it considered that continuous surveillance of the prisoner, whether he was continuous to be a prisoner even after release or not, is a question, is actually violation of his fundamental right to life. Therefore, it cannot be done. Of course, this judgment, especially when it said that right to life is not a fundamental right, is overruled by another judgment recently in Puttaswamy case. It also defined right to life means right to housing, right to health, right to privacy, right to education, right to dignity. All these aspects were discussed in relation to prisoners in 1963. Then came in 1980 the important case Sunil Batra, in which the fundamental challenge before the Supreme Court is the Article 21 uses the word person. The earlier judgments talk about dignity of human beings in relation to prisoners. So the fundamental question before Supreme Court was, especially the Delhi prison department challenged before the Supreme Court whether it might look very odd today, at that time, whether prisoners are persons or human beings. They had doubts what to do. If we say that this is how they thought, nobody will believe today. But of course, even today, a lot of people believe that. At least in popular culture, every movie shows that who said you are a human being, and the hero kicks the villain and sends him into the prison. You are not even a human being. You are not even a person. This echoes what the system thinks about whether prisoners are human beings or persons. So what is the explanation or justification given by the Supreme Court for saying that fundamental rights are applicable to prisoners? Its reasoning is, Constitution promises dignity in the preamble, and it doesn't say that offenders do not deserve fundamental rights. It is trying to say that the fundamental value called dignity, which is there in the Constitution, is equally applicable to everybody. Therefore, the state or executive cannot argue that this value cannot be extended to the prisoners. So now they have accepted that the prisoners are not animals. That is the first necessary thing in order to treat them not as animals, because prisoners were being treated as animals, and then therefore they also argued that prisoners are not human beings. They will not say that prisoners are animals, but they will say that they are not human beings. Okay, this is how roundabout argument. Then again this question after 3 years, again it came up in another case in 1983, whether those who are punished deserve fundamental rights. See, in Sunil Batra case, he was a dreaded gangster and he was under trial prisoner. So they thought maybe in case of under trial prisoner, Supreme Court said that he deserves fundamental rights. But those who are already under punishment, whether they deserve fundamental rights or not is the challenge before the Supreme Court. That is the first time Supreme Court said, especially in case of Vatiswaran and versus state of Tamil Nadu, that prisoners cannot be equated, convicted prisoners cannot be equated with under trial prisoners, all right. But still, prisoners are sent to prison as punishment, not for punishment. In the name of punishing prisoners, you cannot treat them like animals. The very fact of sentencing somebody into confinement itself is a punishment. It cannot go beyond that. Okay? It means a lot of things. What is that? The first thing is foregoing right to mobility. Physical right to mobility is the only right that they lose. All other rights must be restored which are available for the citizens. So that is that is, I mean, very incremental in its approach in raising prisoners. In any case, state went on opposing, giving more rights for the prisoners. Now the question of a physical restriction has been settled. You can only physically restrict a prisoner, but beyond that you cannot impose any other kinds of restrictions. But again, lot of questions. In other cases, the question was how much of physical restraint is permitted? Can you chain them? Can you use bar fetters against them? Can you prevent them from freely moving within the premises of prison? These cases also kept on recurring before the Supreme Court. So then the question was, in some cases from Maharashtra, whether solitary confinement can be considered as a legally valid constitutional form of punishment. That is the fundamental question. Because he said that punishment is is legal. Then again it has to say, of course we have said that you can only impose physical restrictions. That did not mean that you can preserve the body and kill the soul. That is not the purpose. Keeping somebody in a solitary confinement is unconstitutional. It is against the fundamental rights chapter. So therefore, solitary confinement cannot be legally imposed by judiciary itself. Actually, until 1980, solitary confinement was a judicial punishment imposed by courts. It's a British law. Only after 1980, the solitary confinement was declared as illegal. You know what is happening now? Solitary confinement has taken a new avatar now. Now it is imposed as a cellular punishment. or separate punishment. Still, the prisoners are kept in a room and all other prisoners are prevented from talking to him or interacting with him or communicating with him. And even when that was actually challenged in several cases, you know what they are doing in Hyderabad? Recently also it came to our attention. The prisoner is kept in a big barrack where there can be 60 prisoners. But all 59 prisoners are removed from the barrack. And they told that no, he is not kept in a solitary confinement. He is only one person, but it is not a single cell, small cell where you can move, but it's a very big cell. There is a courtyard, everything. So, still physically it is a solitary confinement. So, in this case also particularly they said that depriving a person of all sorts of social communication is killing the soul of the prisoner. So, therefore, that cannot be imposed. But still, that is also being, and prison manual still there are cellular punishments and also separate punishments, separate confinements.
Let me take a pause here. It is the question in my mind. I don't know if any of you have it or. When we keep saying dignity is an individual right, whereas here clearly you're looking at it as a question that to keep a person in solitary confinement is robbing them of their life and liberty. Is there a contradiction when we say dignity is individual in scope in this context? Or do you think that this is a very different context? There's nothing to do with it.
So the dignity basically, which is inherent.
So throughout we will hear it. Dignity is essentially located in the individual. No, are you looking at confinement as violating dignity, or there is no dignity violation here? It's only liberty violation. But you just said right that the idea of a human being as located in society, not as an individual, it's integral.
See, let me a little bit explain how I see. See, the Nelson Mandela rules, and also if you see any Western movie, you will see prisoners have single cells. But here, except political prisoners, nobody wants a single cell.
Nobody wants or nobody is given?
No, nobody wants. It is the differences in the cultural context. Here, community life is so big that keeping, giving a separate room for yourself is considered as a punishing you. So we don't have in India the practice of giving a separate room for yourself. Of course, during night you retire to your room and then during daytime you mix with everybody. That practice doesn't exist in India at all, in any prison. And if you are kept in somewhere, so for that matter, in Nelson Mandela rules I was I was reading, it says, confining two people in the same rule is undesirable. Actually, that kind of formulation in Indian context is unthinkable. Not only two people, 5 people, 10 people, even 2 people are also sometimes kept in the same room. The differences in the cultural understanding of what happens doesn't apply, in our context. So, if somebody is given a separate room and he is asked to leave, they always consider it as a punishment. The only political prisoners are the prisoners who are sentenced to death. They are kept in a solitary confinement, especially those who are sentenced to death. But political prisoners always wanted, not a solitary confinement, but a separate confinement where they will run their classes and they have trainings, reading books, and so many things. No other category of prisoners except ultra leftist political prisoners. No one else prefers solitary confinement. Now, I'm saying this because, see, the dignity rights law, even Nelson Mandela rules talks about inherent human dignity, okay, and humanity. Just because people are willing to live together doesn't mean that they don't have it. They love a collective life in a barrack. 50 people, 30 people, 20 people will live. Of course, that has become unlivable also. That's a different story. Because of overcrowdedness, I'll show you some photo. It will be very harrowing. You feel very bad to see them. But even if we apply those things, the inherent dignity is there. In order to ask other questions, the way that they are treated, the way that they are punished, and the kind of offences that are still part of a colonial prison manuals, I think accepting concept of inherent dignity is extremely important. Now, Andhra Pradesh state has drafted a new prison law, which is not yet become law, and even Telangana. So, Telangana law actually uses the word dignity as inherent dignity as central concept around which prison has to be recognized. In the Andhra Pradesh law, there are only two words called rights, and it says as far as possible by expedient that these rights needs to be enforced. So, using the lens of dignity, you can actually critique the entire law. I'll come to that little bit. You will see how it can be invoked. So, over a period of time, in many cases, the Supreme Court went on invoking this dignity and also fundamental rights as a foundation for offering compensation. In Rudulsa case, it offered 35,000 rupees because he was illegally kept in custody for 14 years. And in Sebastian Hongre case, that in Nagaland, the person disappeared in the hands of the army using the theory of last seen theory, that the Supreme Court believed that he was perhaps he was killed by the army, but still it only gave the compensation, but he did not try to prosecute the people responsible. And a MLA who is from Jammu Kashmir, it's a very famous case when he was illegally detained, and again Supreme Court granted 50,000 rupees compensation. And India has not ratified Convention Against Torture so far, despite signing it 10 years after the whole convention came into existence, which basically prohibits cruel, inhuman and degrading treatment or punishments. And from other countries, when we get some recommendations and some requests for giving reports about prison conditions as experts, one question they ask is, what are the consequences of India not signing Convention Against Torture? Whether the fallout of this kind of refusal to sign Convention Against Torture by Indian government can be seen in the way that police stations are run or prisons are run. Whether indirectly it is admitting that we can't but administer ill treatment or cruelty or soft punishments. Is that what they are trying to do? What is your opinion as an expert? They are asking. So people are able to understand the consequences of not signing or not ratifying. See, if we ratify Convention Against Torture, like so many other countries, Germany, Colombia, Germany, South Africa, so many countries, almost some 50 countries have made domestic laws prohibiting all forms of cruel treatment. But we are not willing to do that. So let us suppose that all the rights that are applicable to citizens are also applicable to citizens, but the question is how to achieve them. But there are so many changes in the law. 39A came into existence in the Constitution and the legal aid. Several methods came into existence, but now we don't see much difference. In 1979, as a law commission chairperson, H.R. Khanna feels shocked that 55% of the prisoners are under trial prisoners. I don't understand what would you say now when he understands that 80% of our prisoners are under trial prisoners. So there is a great improvement from 55 to 80%. How they are being treated, what is happening, I will not go into that detail, but I will only go into how prisons are administered as per the manual, what sort of power is vested in the hands of the administrators of the prison. That's something that I want to say a little bit to give you a closer look at ground realities. The first thing we can use Nelson Mandela rules as the background to assess the kind of laws that we have in India. Okay. So Nelson Mandela rules clearly say that the separation of a person from the society automatically becomes very inflictive. It inflicts a lot of suffering on the person. Beyond that, state should not have a policy that aggravates the conditions of living of the prisoners. This is a broad guideline, okay? And it also tries to say that the difference between living conditions of a citizen and living conditions of the prisoner should be minimized as much as possible in order to see that there will not be any wide gap, so that when they are restored to the society, they will not see much difference. Okay. So the differences between life and liberty of a citizen and that of a prisoner should not be so wide as it becomes almost impossible for them to come back. So Nelson Mandela rules also says that indefinite and prolonged solitary confinement is a big no. No state should resort to this kind of thing. Actually, it also says solitary confinement can be as a last resort. But in any case, the Indian Supreme Court clearly said, solitary confinement at any cost, you cannot impose it. It also says that dark and constantly, lit cells, corporal punishments should not be imposed on the prisoners. You cannot even give a penal diet, and you cannot impose collective punishment on all the prisoners. So these are the broad standards that are specified by the Nelson Mandela rules. So Nelson Mandela rules has 70 years of history. It was initially drafted in 1955. Standard minimum rules, and then revised, and the debate went on for 5 years across the world, and all of them came together in 2015, and it was drafted. It says that it might differ from one country to another country, but there are still some universal principles of treatment of prisoners should be respected by all the states. And it also talks about the agency of the person, autonomy of the person, and sanctity of the person should be respected. So in any case, what is the nature of relationship between the prisoner and the reformer? Definitely not one of equality. So that itself sends certain kind of dynamics between prisoners. And in any case, there is a lot of scholarly writing that soul is the prisoner of the body of the prisoner. So in the name of controlling the body, you are trying to control the soul. So reformer has serious access to the soul of the prisoner, and reformer has the moral power to reach out to all corners of the soul of the person by controlling the body of the prisoner. So without controlling the body of the prisoners, his soul cannot be reformed. In any case, his agency is deprived of all his agency to make right kind of choice in his life. There is nothing like agency or autonomy for the prisoners. To reform him, he must be watched all the time. and he should also understand, he is under constant surveillance, but he doesn't know who is watching him. So this kind of asymmetry of gauges between the prison and also the prisoner, has a lot of implications for ability of the prisoner to assert their rights. If every next prisoner is actually, I'll come to that a little later, how prison rules makes everybody an informer. Every other prisoner is made. No, refusing to be an informer against your next prisoner is a punishable offense. I'm only giving you one example, but I can give a lot of examples. In any case, in the Indian Prisons Act of 1894 continues to be the governing law. Though many states are forced to change their law, they are attempting, but substantially they have not changed because prison manuals, rules, they determine the method of dealing with the prisoners. Okay, so I mean, Act is doesn't go into deep into the rules of treatment of the prisoners, but prison manuals graphically. Actually, some 25 years back, 30 years back, when I went to a prison in Hyderabad, by chance I came across a document which has graphs how to torture. I preserved it for a long time within my archives. The methods of torturing. Graphically, it is written. If you read Ardhashastra of Kautilya, it is very contemporaneous. Ardhashastra, we think that it belongs to second century. The methods of torture it describes are very contemporaneous. I believe that we have not changed almost for 1800 years. Removing nails is described very in detail. Water treatment is in detail described in Ardhashastra. And it also says that the people who belong to lower caste should be subjected to this kind of treatment. Still, the same thing is still happening. I will come to little bit. See, the Prisons Act has this section 45 to 53. They say that what kind of rules needs to be drafted into the prison manual, and this is a colonial manual still in existence in Andhra and Telangana and also in other states also. There are more than 1100. In Telangana, it is 1111 rules. Graphically, I mean, they minutely govern every movement, every breath, every walk, every movement of the prisoner. Okay. So substantially, it has not changed at all. And in the entire 1100 prison rules, there is not a single word called right. Everything given is only a privilege, which means it can all be taken away. As a matter of fact, no prisoner in India has right at all. And there are 55 forms of human behavior. I mean, if I read some of them, you would feel very ridiculous. 55 kinds of human responses and behaviors which are prohibited as an offense. And it also prescribes some 45 kinds of punishments. As single punishment, as a combination of punishments, they can all be imposed. And all these, violation of all these rules have serious consequences for the life of the prisoners. And prison manual also says that the abstract of prison rules should be like Nelson Mandela. I also checked long back. Nelson Mandela rules also say that the prisoner's rights and duties as an abstract should be displayed in the prominently visible place in the prison. But I must have visited some 500 prisons in India. I have not seen anywhere in India in the local language. And some 20 years back, State Legal Service Authority asked me to write in Telugu rights and duties of prisoners. Some 10 page. They published it also. But the prison department refused to take it. They don't want to distribute. So at the time of every admission of every prisoner, they should be read all the rights and duties that they have in the prison. That never happens. When I take students to the prison, we always wait at the place of admission only. We see dozens of prisoners sitting, but they are never informed of what are there. When they are produced, they are asked, "What is your father's name? What is your address? What is your Aadhaar card? Where are you from? Which police station? Which magistrate?" These are the only details. They are never read what are their rights or duties. And also this prison manual, I have a copy. I got long back, almost 30 years back. It's a secretive document in the prison. It is never given except to the political prisoners. Political prisoners threaten and they blackmail, whatever they do, they are given, but not the ordinary prisoners. And all the standards set by the Supreme Courts and the High Courts over a period of time, 50 years, have not found their place in the prison manual. It's a completely parallel. If you read that book of Kafil Khan, you guys remember Kafil Khan? Dr. Kafil Khan of Gorakhpur was a doctor, medical doctor, and he tried to save children from death of oxygen in UP. He was sent to prison for 2 years. If you read that book, one thing it says is, he almost says that Uttar Pradesh prisons are a complete independent state. Who is chief minister, who is the home minister, it doesn't matter. Which party is in power is also doesn't matter. There is a very well organized system of extraction of money for everything, and it is distributed from lowest level to the highest level. And which political party chief minister is in power, it's irrelevant. So that way I see prison as one of the fundamental institutions that has not changed over a period of time. Even Nelson Mandela rules also have not found any place in the prison acts. Though central government once or twice sent some circulars to West Bengal government and Tamil Nadu government, they are all trying to reformulate the Prisons Act. But when I tried to take a deeper look into the nature of manuals they created, they have nothing to do with Nelson Mandela rules. So what constitutes a prison offence? Which has something to do with, seriously to do with the question of dignity. Prison officer has power to ban the prisoners from talking, from loud laughing, singing. Singing is banned, loud talking is banned. And not following the order is considered as a punishable offence. In practice, the prisoners are totally banned from openly engaging in any conversation, laughing or singing, except for the privileged prisoners. Every article not permitted by the prison, including book and pen, is a contraband. And Professor Panduranga, long back, some 40, 50 years back, he went to Supreme Court demanding his thesis, doctoral thesis should be published, which prison department did not allow. Answering unfaithfully any question to visitors will attract punishment. Communication with opposite sex, even if it is your partner or even if it is Tying to prisoner of another class is banned. In practice, it bans all reasonable communication between even wife and husband if they are in the same prison in different barracks. Abatement of any offense will also attract as much punishment as that of a substantive law, like in IPC or in BNS. Refusing to be an informer, refusing to snitch on other prisoner will actually attract lot of punishment. So what it does is it completely erodes the confidence of every prisoner and forces them to live in fear. They will not talk anything and they will not, they're infantilized. They will not take any initiative. Any initiative taken in the prison is seen as a kind of a mischief. So prisoners are restricted to specific barrack, ward, though there is a huge space to roam around. Only privileged prisoners are allowed to go from one side of the prison to another prison. Loitering in the prison is a biggest offense. Idealism, being ideal, not working, is a punishable offense. It has a long colonial history. After British introduced a lot of industries in the prison, when a prisoner refuses to work and tries to be ideal, that has become a punishment. So these are, this looks like some mad rules. No, all these rules have come up at a particular kind of historical conditions. So they are not just written to control them. There was a lot of resistance also within the prison at one point of time. And visiting a toilet at any time you want is also punishable offense. You have to go only when they permit. Refusing to eat a food, fasting in the prison. How many years, how many months Gandhi must have fasted in the prison? Why only Gandhi? No, fasting was a punishable offense during colonial period in response to nationalist movement. Still continues to be there. So now Andhra Pradesh government has made this prison law where they say that prisoners cannot assemble and talk. I told them that right to free assembly is a fundamental right. Are you writing your own constitution or what? They did not like my suggestion. They are very angry. Refusing to, not only political, there are so many other reasons why the prison management has become what it has become now. Refusing to clean yourself, clean your hair and nails and body is a punishable offense, because in the early 20th century, the problem of controlling contagious diseases in the prison is the biggest public hygiene problem. Things that became offenses at that point of time still continues to be there. I don't see why they still continue to govern the prison conditions. Chicken pox was a serious problem earlier. In 1920s, in the first quarter of 20th century, prison mortality was 25%. Actually, all prisons were almost were run like hospitals. That is why prison has warders, like in a hospital. So all those rules have come at a particular historical junctures, and there might be need, they may not be need, but once they came up, they started accumulating. They still remain as a seriously useful instrument in the hands of the state. Even after independence, after constitution also, these rules still continue to govern. Self-harm is a punishable offense. Unauthorized cooking is a punishable offense. Possessing books, letters, postage stamps are punishable offense. These were also introduced in response to nationalist movement. The nationalist leaders in the prison, they used to use communication with one another and strategize and start agitations. Those rules, I don't understand why they still have it in the prison manuals. In any case, for these 55 kinds of offences, they can have an inquiry. The prison superintendent is the prosecutor, judge, jury, everything. Now, what comes to my mind is, see, if you see POCSO Act and also all the sections against sexual violence, especially rape, there are elaborate rules about a fiduciary relationship. That is, if somebody is sexually violated, who is in the control of a person who is trusted person, employer, nurse and a doctor, teacher and a student, or a guardian and a ward, different kinds of inquiry, different kinds of rules of prosecution are also in place. I don't understand why same is applicable to prison, where there is a fiduciary relationship between the prison officer and the prisoner. No outside person is part of the entire process of inquiry. A prisoner, one prison officer accuses him of doing something, resorting to some offense, and another prison officer inquires and prosecutes and imposes punishments. I have been arguing that for prison offences, prison officer should not be involved in imposing punishments. There should be outside authority, external authority. Even in Committee Against the Sexual Harassment in Public Life, we have people who are external person who is part of inquiry. Why prison we are trusting so much prison executive? It should be changed. So there are a lot of punishments. I will not go into details of those punishments. The punishments include forfeiture of your freedom, remission, denial of interviews, visitation rights. You will be prevented from meeting your parents or your spouse or children for 3 months. That is a form of punishment. And handcuffs can be used. It also gives a graphic description of 910 grams weight. It should be 910 grams. Bar fetters can be used. It can be for 1300 grams. That is a limitation which can be used against a prisoner. Penal diet. This is the recommendation of a medical officer. There is so much of literature how science, medical science continuously helped the state in imposing a cruel punishments. There is an international covenant on ethics of physicians, especially on questions of custody. So that kind of covenants are not invoked. Here, doctors are subordinate officers to the prison. So penal diet for a prisoner, if he is given 1,000 kilograms of food per day, as a form of punishment, it is reduced to 450 grams. And it imposes certain kinds of precautions. When you are imposing penal diet, please don't expect them to do hard labor. Very kind, no? And cellular punishment can be imposed for 1 week. Solitary punishment can be imposed for 15 days. And between two terms of solitary confinement, there must be 1 week of gap. It's a very clinically administered cruelty. 1 week of gap is how to if we want to defend them, how do we do this? It has nothing to do with dignity. This whole regime that exists in the statute has nothing to do with dignity, prison of dignity. The prisoner, as a form of punishment, prisoner can be excluded from 3 months of remission, which means every prisoner earns 5 days of remission per month. If 3 months he is excluded from that, for 15 days of remission he has to undergo, which means he will be released 15 days later than that he deserves to be released. So prison can also impose a combination of punishments. Not that these are all very widely invoked against prisoners. No. Only 5% of prisoners are subjected to this kind of punishment as a warning, as a signal for all other prisoners to fall in line. The rampantly they are being subjected to cruelty. No, I'm not saying. But these authorities are there within the hands of the prisoners, in the hands of the prison officers. Now, one or two things that I want to propose as practically what can be done. If we are a lawyer, if your client is being remanded to the prison, you can argue in the court. Let us try. In other countries, they are trying to do. This is you want to send this person to the prison, local prison. Its capacity is 100, but there are 300 prisoners. So therefore, there are inhuman conditions of living. Why do you want to send him? There is no doctor. In the same barrack, there are open toilets. Prisoners, my client will not have any kind of privacy. He has to sleep with 100 people. You can argue that please don't remand my client to the prison. You impose any conditions, house arrest, any other condition. These inhuman conditions of living in the prison are widely invoked in Europe and America against prosecution, and courts are allowing that they are not sent to the prison. Here judges are saying every day there are in 2022 with the last statistics we have. In 2022, 1,850 prisoners died in the prison. Anybody can invoke that fact. Why do you want to send my client to the prison? This any lawyer should be able to do it. Yeah, since in the morning there was discussion about how media deals with the accused and how their dignity is continuous. When I go to prison with students, prisoners mostly ask one fundamental question: what is this, sir? Even before we are sent to prison, the way that they are writing, the way that they are portraying is completely humiliating. They never asked a single question. So I was thinking in the morning, to talk about this. I'm glad that somebody has taken it up as a serious issue. So, okay, in the light of Nelson Mandela rules, you can critique most of the Prisons Act or drafts that are in the pipeline. Only 6-7 states have tried to make a new laws. West Bengal is one of the first states. Haryana, Delhi, and Tamil Nadu. You need to know what are the standards which can be used in order to critique these drafts and also prison manuals. At least in North India, prison manuals are sold in the shops. Anybody can buy. Here it's not. In South Indian states, they are not available. So if you want to do it something very practically, and you must have heard about that judgment, Sukanya Santa, about caste-based discrimination. That is only the tip of iceberg. Going by whatever I read here, there are so many other forms of discrimination and abusive behavior legally permitted. So you need to study prison manuals if you want to seriously understand how the regime is working. As a lawyer, as a researcher, as a social activist, you should know what are the rules. Even lawyers are also not freely permitted. And I run this program. There is great resistance from the prison department as well as even the lawyers associations from freely providing legal aid to the prisoners. Because more the prisoners, more the income. It's like a COVID period for doctors. See, this in all law schools, law colleges, this very naive view that system is very willingly accept all the students to come and provide free legal aid. This is the biggest myth. No, lakhs of people are surviving on the basis of the way that criminal justice system is running. So therefore, even if you want to become a very good lawyer with minimal charges, simultaneously you will find thousands of people languishing in the prison. On the other hand, you will also find thousands of lawyers without work. How do we explain this? So, defending the dignity, and also if you want to defend the dignity of the prisoners, constantly you will always be asked, like, what about the dignity of the victims? As if prison department or government is really dealing with the dignity of the victims. This is no. So this is a socially defending the dignity of a socially discredited section of the population is not easy. I have 5 lawyers, and they file a case about a prisoner who has been there for 90 days. They think that undeserving person is getting released. Prison officer thinks the same way, judge thinks the same way, public prosecutor thinks the same way. Let that fellow be there in the prison for 1 more year. Why are you trying to get him out freely? We say, after all, he is still accused. We don't have any issue if we are going to prosecute him as per due process of law and then convict him. We don't have any issue. I want to tell the students, we want to take a serious research. One area I want to see, in all long pre-trial detentions, please find out whether state is seriously showing interest in getting them convicted. Take up some 10 cases where prisoners were there for 5 years as under trial prisoners, and then see whether the prosecution has seriously tried to convict them. No, invariably they fail because they are not interested. My hunch is state is fundamentally interested in punishing the accused even without proving anything, as long as possible. The consequences of that is that nobody now believes in the rule of law. Prisoners will keep on saying that what is this nonsense, what is happening? Yeah, please.
Sir, and sir, I also think that the issue of legal aid lawyers in general also, they like many a times the state appointed legal aid lawyers, they also don't find institutional support. So many a times they won't have salaries which will help them to work in proper conditions or have offices where they can meet their clients. And it's even worse in some cases where there is no like overall institutional support for the legal aid lawyers because they have to give good enough legal aid and advice for these under trial prisoners to get out. So I see some vested interest there and some sort of application of responsibility from the part of the state when they don't support legal aid lawyers.
See, in the past 1.5 years, Supreme Court came up with a new system of defending it is called LADC, Legal Aid Defense Councils. Like public prosecutors, the other side, defense counsels are also permanently appointed. They are paid very well. But no, they are not interested and they can't defend everybody. And so now the question of paying them decently, that question no longer is applicable. But when we go to prison, most of the complaints are against this LADCs. They take, last year, September, just before retirement, Chandrachud has released a report by Supreme Court on prisons. There are 20,000 prisoners in India who got sureties, who got the bails, but not sureties. It's a very conservative number, I can tell you. 20,000. In Telangana alone, there were 600 default bail holders. Those who completed 60 days and 90 days, therefore courts have granted them bails, but they did not have money, therefore they were not out. In 20,000, I think there are substantial number of cases where the lawyers have taken some fee and argued, and then they refused to process the sureties, demanding more money. It's not an anecdotal incident at all. No, it is not anecdotal at all. So lawyers take minimum fee in the beginning and then argue and get the bail, and there is so much of debate about using technology for easing the prisons. Okay? In 2021, Supreme Court has given a order saying within 24 hours or by next day, every bail order, every judgment should be sent to prison, and it should reach the prisoner. That has not been implemented so far. Tell me, who are the beneficiaries of not applying this rule? Judges say that we are giving this order only to the advocate. Advocate doesn't take it to the prison. Simply, let us talk very frankly. There are substantial number of lawyers who are just blackmailers, nothing more than that. In other forums, I can't say these things. So this is a fact. If it looks like a very activist anger, no, it's not. Who can, you tell me, Bar Council has a code of conduct about professional ethics of lawyers. You tell me, in the history of Bar Council, in the past 70 years, how many lawyers were taken to task for their professional misconduct, especially with their clients in the criminal justice system. As part of our clinic, actually 2 years back, our students had gone to court and they wanted to interview lawyers, advocates. What do you think of professional misconduct? Bar Council rules. Believe me, no lawyer was willing to talk. So these are all questions of, so you get the bail, still you are there for 3 months, 4 months, 5 months, 6 months. Here what is happening? It is not just prison officer ill-treating a prisoner. No, there are a whole series of people who are making their livelihood at the cost of dignity of the prisoner. If it is an individual problem, we can solve. No, we have built that kind of system, unaccountable system or insensitive system, which doesn't want to address the question straight away. So how do we address, in this kind of atmosphere, talking about the dignity of the prisoner is almost impossible. And Justice Muralidhar, in his conversation with the NLS, he says the judiciary is interested in plucking the low-hanging fruits. They are very, very happily try to say overcrowding in the prisons is very inhuman, but beyond that they don't want to touch. It's very easy to say that we are also bleeding hearts, that we feel very bad about overcrowding. No. The courts and lawyers know very well. They know very well what is causing overcrowding. How many lakhs of people in India are in pre-trial detention more than they deserve? I'm not saying that all the pre-trial detainees are angels or anything. At best, they have to be there for 3 days, 4 days, as a matter of warning. You are a source of anxiety for the victim of crime. You are not behaving yourself. To prevent the risk to the victim, you need to be sent to prison. It's a warning that legitimately criminal justice system has to give. But where a person needs to be there for 3 days, 4 days, ending up there being there for 6 months, 1 year, 90 days minimum, especially in murder cases. The one single question that I want to ask is, are all pre-trial detentions legitimate? Even under our Access to Justice project also, not that now somebody was going to prison today and we are getting him bail tomorrow. No. There is this whole obedience to the legal system by the lawyers. No lawyer, especially lawyers who have less than 10 years of experience, want to confront judicial system. They understand this judge gives bail only after 60 days. Before that, I don't want to file the bail. My source of livelihood is at stake. In all POCSO cases in Hyderabad, nobody files a bail before 45 days. Except those who are very privileged, who can go up to Supreme Court. An average lawyer refuses to file before 45 days because judge doesn't want to give. We want to send a strong signal that are under protection of children against sexual exploitation. The moment you accuse somebody, they should be sent to prison up to at least 45 days to 60 days to 90 days. This is an unwritten code that is actually governing the process of protecting or denying the freedom by the criminal justice system. Written code doesn't have anything to do with this. Then how do we protect the dignity of the children? In prison, I can say that after so many years of work, at least 15 to 20% of prisoners are adolescents between 18 to 20 years, who don't need to be sent to prison at all. Dharmavira Commission in 1979 said 60% of the undertrial prisoners don't need to be arrested in the first place. It's a police commission. It's not a judicial commission. It's very stressful to see young people, sent to prison. And alternatives. See, if you are involved in a drug case, in other countries, 2 options are given. Do you want to go to prison or do you want to go to de-addiction center? We don't have that option at all. In India, there is no judge gives this option. Do you want to go to de-addiction center or you want to go to prison? In all Scandinavian countries, first option is going to de-addiction center. What are we doing here? You see the Punjab, how every year it's more than 200 deaths are especially drug-related withdrawal symptoms. Every year more than 175 to 200 people are dying in Punjab. Prisoners. No de-addiction centers. They don't need to be sent to prison. Young people. How are we defending the dignity of the people in conflict with law? Dignity is a banned word in the premises of courts and prisons and police stations. We also talk to prison officers, sometimes even judicial officers. They think that we are just idealists talking some nonsense. The world works in different way. That is how we are treated. So young lawyers, we are also taking very young lawyers for our program to deal with this clinical program. So we don't think, system making even lawyers very insensitive over a period of time. So protecting them, keeping them sane and working with the ideals of dignity is not an easy task. We are trying as much as possible. Don't know we are going to be successful, but giving up is not an option. Therefore, we are still hanging around and trying to do this work. I stop here. If you have any questions? Most you must be able to say what is the debate around this electronic devices used for pre-trial detention. Now it is catching up.
Ankle monitors.
Yeah.
Yeah.
So is it critical from the lens of dignity?
Yeah, I think it's a potentially valuable option because being detained is just a worse violation of dignity.
Okay.
Period, right? Under any circumstances.
Okay.
So if you can accomplish the goals of pretrial detention, which is to keep people safe and ensure that the person will show up at trial, if you can do that without detention, but just with some kind of ankle monitoring, that's preferable.
No, but then what happens to the identity of this person pre-society?
What happens to their
identity of this person, the stigma,
it's
humiliation?
It's obviously worse than being free, but it's a whole lot better than being in detention. Like if the alternative is pretrial detention, my guess is most anybody would want it.
See, recently there was a case before Delhi High Court where the prosecution demanded live Google location of the person.
Yeah.
The court said no. That is actually killing the privacy of that person and individual dignity of this person. That is not acceptable.
And when the alternative is detention?
No, I mean, they granted the bail, and this is one of the conditions they demanded.
So they were going to.
They said, no, you take away the passport, we don't mind.
Yeah.
It's a no flight risk.
Right.
So, no, I mean, technology seemed to be a kind of solution for all the problems. That's never true. Again, here, I am very apprehensive about usefulness of
AI and in the morning you were hearing someone? AI? Yes. Do you have any comments on this? What the use of AI, let's say? But I think you were doing it more in terms of violation of the privacy of victims of crime rather than people accused of crime. Right? Yes. I think you're right that surveillance, both pre-trial and also we have a tremendous problem with surveillance upon release, pose very, very difficult privacy issues. And as surveillance gets better, they pose even more significant privacy issues. In addition to that, we also have a problem in the US with costs, because what some courts will say is you don't have to go to pretrial detention. You can wear an ankle bracelet and you have to pay $50 a day for the ankle bracelet. Like, it's insane, right? So there's that issue also that gets visited upon people who are accused, who are technically innocent, right? Remember, in all this conversation, they are innocent until proven guilty. And yet they're treated as if they have to.
I also read in America, the Prison Guards Association and Probation Officers Associations and Prosecutors Associations, they are trying to ensure that prisons are full. They demand over a period of time, the person who is released on parole is arrested immediately. No, these conflicting interest groups are developing to ensure that the system is providing some sort of source of livelihood. Then how ethical this system is a question that we need to seriously think.
I think to me that's one of the reasons why looking at all of this through a dignity lens is really important, because otherwise you can forget that we're talking about human beings.
Yes.
Right? And so there's the economics of it, and there's the social, keeping communities safe, and there's all these other interests. And if we consider all those interests, and maybe they're important, but if we consider them without considering that there's a human being, a human life, a human person at stake, then we lose sight of what's important.
See, something is happening, for the past 10 years or so. There is some kind of a different kind of movement in the perception of people. It appears to me citizens per se are not against violence. Or the universal protection, equal opportunity, equality before law, these concepts are losing their legitimacy, or people are losing their trust in this, because now every organized group tries to argue before the state to bring a law to protect them exclusively. Lawyers demand that there is violence against, please protect us. Doctors separately go and ask that there is violence against, please protect us. Every small, for that matter, all violence against anybody is per se is prohibited. So that is no longer is working. Every small organized group is trying to say, please protect us. So they are demanding the state. Recently in Hyderabad, lawyers are demanding that a law should be brought to protect the lawyers. They should also see how ethically they are dealing with their claims. Instead of saying that, in the past 3 months, they boycotted courts some 10 times because clients are attacking. 10 times. And they went to the government asking for a law. Please protect the lawyers. Doctors also doing this. So suddenly somebody who is observing this whole thing has to ask this question, whether violence per se prohibited by law at all.
In the US, the most often place you see the word dignity in state constitutions is with respect to Victims' Bill of Rights and victims of crimes and procedures that are put in place to protect the dignity of victims. So it's really interesting because.
What about to the dignity of the victims of the system?
Yeah, right.
Unless there is specifically disregarded by the Constitution. One has to ask that question also.
Just dignity of every person.
Yeah.
So there were at least 2-3 projects, right, on the criminal justice system. One was the AI business. What were the other ones that we heard in the morning? Any specific questions from there?
About women in prisons.
Yeah.
Yes. Yeah.
Do you have any questions, any follow-up from there?
No, actually, Murli sir already shared a lot of contact details with us, and we are going to be following up with them and then getting some sort of insight.
So we know that 377 is decriminalized by Supreme Court, consensual homosexuality by the same sex. All prison manuals, even new laws written by the states, still consider homosexuality is a serious crime in the prisons. So that's what I am saying. The great pronouncements by the Supreme Courts are not reaching at all to the states, and scholars are not watching or not saying anything. So this wide gap between the Prisons Act written in 2025 are saying that homosexuality is a punishable offense in the prison. And what about consensual partnership? How do you punish it? Somebody has to ask this question.
And there was another project, Sachin, I think you were doing a project on disability prisons.
Yeah, Sachin, I can send you this document. The one that we have submitted to Supreme Court as part of a disability rights case. The specific thing that I have done is how persons with disabilities are treated by the prisons, and in the judgment also they have put it as an attachment. The one they have written. The Disability Rights Act recognizes 18 forms of disabilities, but prison laws identify only 4 forms of disabilities, which means the prison manuals, prison practices, and prison act doesn't even recognize other 14 forms of. So therefore, there is no collection of data on other forms of. Mental health is one of the biggest forms of disability that prisons recognize. Visually challenged also recognize, and physically challenged also recognize. There is one more, hearing impairment. But other than these things, other 14 forms of disabilities are not even recognized for the sake of collection of data in the prisons. So that is what we have written, and the judgment also even Chandrachud has written a little bit about this state of affairs. In the judgment also it is there as an attachment, otherwise I can send it to you. I've given some 5-6 pages of report.
And often I think mental health challenges are both a cause and a product of
Absolutely.